All rise.
Kosovo Specialist Chambers is now in session.
Good afternoon and welcome everyone. I'm Judge Picard, presiding judge in this case. Madam Court Officer, could you please call the case?
Good afternoon, Your Honors. This is case KSC CA 2022-01, the Specialist Prosecutor versus Hisni Gucati and Gucati&Haradinaj.
Thank you. Now I turn to the defense, starting with counsel for Mr. Gucati.
Your Honour, I appear on behalf of Mr. Gucati. I'm assisted by co-counsel Ms. Eleanor Stevenson, also by team member Mr. Gucati&Haradinaj.
Thank you. Now counsel for Mr. Haradinaj.
Good afternoon, Your Honour. Toby Cadman for Mr. Haradinaj, joined today by Ms. Bernabel, Mr. Berisha, and online Mr. Buckley.
Thank you. Now I turn to the registry.
Good afternoon, Your Honour, and good afternoon, colleagues. Jonas Nilsson, Head of Judicial Services Division, representing Registry.
Thank you. I note that Mr. Haradinaj is present in the courtroom, and I also note that Mr. Gucati has waived his right to be present at the hearing. That's true. I forgot the SPO. I'm sorry.
Not at all, Your Honour. Appearing for the SPO today...
That's the first time, you know, so...
We quite understand. Appearing for the SPO today is Deputy Specialist Prosecutor Alex Whiting, Associate Prosecutor James Potch, Case and Evidence Manager Lena Peterson, and I am Prosecutor Matt Halling. Thank you.
Thank you very much. Okay, before we start, I would like to recall that Judge Ambos and Judge Jorgensen and myself have been assigned to the Court of Appeal panel to decide on this appeal against the trial judgment issued in this case on 18 May 2022. In accordance with Rule 178 of the rules, the purpose of this pre-appeal conference is to give the accused the opportunity to raise issues in relation to their detention, including their mental and physical condition. To this end, on 22 June 2022, I issued an order on behalf of the panel to convene this pre-appeal conference and to set out the agenda to be followed during this hearing. For today's session, I would like to request the parties to present their submissions in a concise manner and to avoid repeating written submissions on matters either pending before the panel or already disposed of. I'm referring here to the SPO's request to maintain the accused detention. This matter will be decided in written. I'm also referring to Mr. Haradinaj's request for an extension of word for the filing of his appeal brief and to the SPO's request for an order to Mr. Haradinaj to refile his notice of appeal. The parties have already been notified on of the panel decision on these issues last Friday. Likewise, the panel has dismissed the request filed by Gucati for an extension of words to refile his notice of appeal in a decision filed earlier today. I would like to recall that we have to use our time as efficiently as possible, given that this hearing must be completed by the end of today. I would also like to remind everyone that a few rules must be observed at all times in order to make for an effective courtroom process with an accurate record. Bear in mind the necessity of a good translation, which requires a bit of additional time sometimes after you have finished speaking. Please rise to ask permission to speak and do not forget to use your microphone. This hearing is transcribed in real time and will be reflected in a transcript available to the parties and to the public. I remind the parties to give prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. Hope I'm not going too fast. As per the scheduling order setting out the agenda for today, I will first hear submissions related to the accused detention. I also informed the registrar that I would invite the submission on the progress made on the translation of the trial judgment into Albanian and its expected finalization. In addition, I have a couple of subsidiary issues that I would like to raise on behalf of the panel. The panel and the parties have been notified that the defense for Mr. Haradinaj wishes to seek clarity on whether the substantive appeal will be heard by way of oral or written submissions, or whether the defense will only be allowed to make written submissions. The defense team for Mr. Gucati has not informed the panel of any additional matters to be addressed today. Finally, I note that the SPO does not wish to raise additional issues today. Today's hearing will be conducted in compliance with this agenda. Accordingly, I will invite the defense, starting with counsel for Mr. Gucati and then counsel for Mr. Haradinaj, to raise any issues related to the detention of the accused they respectively represent. I recall the defense to request that we go into private session should they wish to refer to any confidential information related to the health or any medical condition of the accused. Now, counsel for Mr. Gucati. I see counsel for Mr. Haradinaj.
Just very briefly, Your Honour, just to say we withdraw the request at this stage as premature as to whether the appeal would be disposed of by way of written submissions or an oral hearing. I'm not requesting that you deal with that matter today, and I can address you on detention after Mr. Rees, but I'm not intending to make any submissions today.
Thank you very much. I was in fact going to say that your requests were premature at this time. Now, counsel for Mr. Gucati, you may proceed.
Your Honour, in relation to the general position on custody, we have submitted a filed response to the prosecution request to maintain detention. Our position, I think, is set out quite clearly in that, and I don't rehearse anything therein. The only other matter that we sought to assist Your Honour with today was an update in relation to Mr. Gucati's health. Mr. Gucati, we understand, and perhaps this is a matter in which we should go into private session, Your Honour.
Okay, let's go in private session, please.
Your Honor, we are now in public session.
Thank you. So the counsel for Mr. Haradinaj has something to add about the detention of Mr. Haradinaj?
Only to say that the position was left open in the written submissions in order to take full instructions from Mr. Haradinaj. Having done that, no submissions are made in respect of detention at this stage, and no issues as to health need to be raised.
Thank you. Mr. Prosecutor, do you have anything to add about that?
Briefly, Your Honor, thank you. Mr. Rees mentioned that the Gucati defense filed a response to our request filing F10 to maintain the detention of the accused. There is no such response in the case record. Nor can we detect a gap in the filing numbers where such a response would be. As far as we're concerned, they are out of time to make a submission on the current detention review, and we maintain our submissions in filing F10 in the appellate record.
Your Honour, can I address that?
Yes, I believe you must address that.
Well, I hope that Your Honour has seen the response.
No, I haven't seen the response.
Well,
May I ask my lawyer, do we have the response? No. How was it sent, by mail or?
so it was sent by email. The matter was submitted for filing within time.
Okay, we'll check if we have that from the CMU.
I can assist in case Mr. Hallin thinks there's anything untoward and there's an attempt to take advantage. I can assist by running through quickly what was the substance of the response. We noted that Article 46, Sub-Article 8 of the law on Specialist Chambers and Specialist Prosecutor's Office provides that unless the trial or Court of Appeals panel orders otherwise, a convicted person shall remain in custody pending appeal. We noted as well that there was no application we had made to either the trial panel or the Court of Appeals panel for such an order. And therefore, we took the view that the prosecution request was neither necessary, nor did it in fact seek or require any order or relief, and we made no substantive response to it. The only thing we do at this stage is, as Mr. Cadman does on behalf of Mr. Haradinaj, reserve the right to make an application for any such order under Article 46(8) for release from custody at any stage in the appeal proceedings with or without a change of circumstances, but I don't make one at this stage.
Okay, thank you. So we read it and we'll take a decision if necessary on it.
Your Honour.
Now, where are we? Okay. Nothing else for the detention? No, on detention. Okay. Okay, the next item on the agenda now is the progress made on the translation of the trial judgment into Albanian. May I ask the representative of the Registrar's Office to take the floor?
Thank you, Your Honor. So with regard to the translation of the trial judgment into Albanian, that is, so it's being done in 3 phases. First, unrevised translation without footnotes was going to be finalized by 20 June. A second, unrevised translation with footnotes by 4th of July. And then finally, a revised translation by 15 of August. So this was the schedule, and that has been respected, with the first unrevised translation finalized and communicated to the parties through legal workflow on the date indicated, 20 June. The second unrevised translation was completed some days ahead of schedule and communicated to the parties again through legal workflow on 27 June. And the date for the revised translation remains 15 August. Thank you.
Thank you. So I remind the parties that 15 August is 4 days before the appeal briefs are due. I believe it's understood, but we'll see if you need an extension of time at that time. Let me now move to the remaining issues in light of the decision we already issued last Friday, ordering that the defense teams refile their notices of appeal. So I will not make lengthy comments on the defects of the notices of appeal filed by the defense teams, and especially on the one filed on behalf of Mr. Haradinaj. Let me just reiterate that the panel strongly disapproved of the failure to comply with formal requirement on appeal. Now I will turn to the issue that has been notified by the defense team for Mr. Haradinaj ahead of his hearing, but we already spoke about it at the beginning of this hearing, whether the appeal will be heard by way of oral and written submission. As we stated at the beginning of this hearing, this question is premature. And I remind you that according to Rule 72.3 of the rules, unless otherwise ordered by the Court of Appeals panel, appeals against a judgment by a trial panel under Article 15, paragraph 2 of the law shall be heard expeditiously on the basis of the case file. Such appeals may be determined entirely on the basis of written submission. So it may be done by written or oral, but only may. And we'll decide depending whether you request an oral hearing or not. I see now, well, it's I don't have any other item to raise.
That's been an efficient use of Your Honour's time.
Thank you. Thank you, everybody, I must say. Mr. Cadman.
Just one quick point. In your order on refiling the notice, you had said 1 week, and then in the decision this morning in relation to Mr. Rees's application, you said the 12th. I just want to be certain that it is the 12th of July for both the Gucati and the Haradinaj notice to be refiled.
Ooh, let me think about that. I'm not so sure. It's, yes, 12. Okay. So I will adjourn the hearing now if there is nothing else to raise. And thanks to the and thanks to the parties and the registry for their attendance and contribution. Thanks to the interpreters. stenographers, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned.
All rise.